April 29, 2026 is a date every gun owner in America needs to write down. On that date, newly confirmed ATF Director Robert Cicada, standing alongside Acting Attorney General Todd Blanche, announced the most comprehensive deregulation package in the Bureau of Alcohol, Tobacco, Firearms, and Explosives' entire history. I will explain 34 separate legally binding rule changes and regulatory proposals built on President Trump's Executive Order 14,206, protecting Second Amendment rights. Dismantled years of bureaucratic accumulation around lawful gun ownership, reversed a 2024 Biden rule that changed private firearm sales, implemented Supreme Court compliance on bump stocks and pistol braces, ended the enforcement policy putting licensed dealers out of business over paperwork typos, and removed regulations making interstate travel with firearms legally treacherous. Acting AG Blanche put the philosophy in one sentence: the Second Amendment is not a second-class right. ATF Director Cicada put the institutional shift directly. The agency's mission is evolving from a mechanism restricting civilian gun acquisition toward an identity focused on violent criminals and international traffickers. Subscribe right now because this package changes things that affect every gun owner, every private seller, every licensed dealer, and every person who has ever driven across a state line with a firearm. Executive Order 14,206 directed the ATF to conduct a comprehensive review of all existing regulations, guidance documents, and enforcement policies for consistency with the Second Amendment, as interpreted through Heller, Bruin, and subsequent decisions. The April 29th package is the implementing action on that review. Most provisions change things that were created by agency rulemaking and can be unmade the same way. Several are proposed rules still open for comment. Others are final rules effective immediately. Some are policy changes taking effect the moment Director Cicada's memoranda reach field offices. Let me walk through the 4 most consequential categories of change and then tell you exactly what each one means for your daily life. Number 1, the private sales rule reversal, the change that reaches the most people. What the Biden rule created. In 2024, the Biden administration used the authority of the 2022 Bipartisan Safer Communities Act to dramatically expand the definition of engaged in the business of dealing in firearms. Under prior law, only those who made their primary living buying and selling guns needed an FFL and background checks. The 2024 rule extended that requirement to anyone selling, predominantly to earn a profit. Broad enough to apply to someone selling 5 guns at a gun show, an individual selling through an online platform over a year, or someone regularly turning over their personal collection. For practical purposes, millions of ordinary gun owners conducting private transactions suddenly needed FFL involvement, NICS background checks, and commercial dealer paperwork for historically private activity. What the April 29th package did. The rule has been rescinded. The definition of engaged in the business is narrowed back toward the statutory baseline: a person whose primary livelihood comes from buying and selling firearms for profit, not a hobbyist, collector, or individual who occasionally sells from a personal collection. A TF published guidance defining the restored standard with explicit examples. Selling from a personal collection does not constitute being engaged in the business. Selling at a gun show when incidental to attendance as a collector does not qualify, and liquidating a collection for any reason does not qualify. What this means starting now: you can sell a firearm from your personal collection to another private individual without involving an FFL, without a NICS background check, and without creating a federal transaction record, subject to your state's specific laws. Several states have passed their own universal background check requirements that operate independently of federal law. Know your state, but the federal requirement imposed by the 2024 rule is gone. Gun shows, online platforms, and direct private sales return to the pre-2024 federal framework. Number 2, bump stocks, pistol braces, and the machine gun definition. The Garland versus Cargill implementation. In 2024, the Supreme Court held in Garland versus Cargill that bump stocks do not convert semi-automatic rifles into machine guns under the NFA's definition, because a bump stock-equipped firearm still fires only 1 round per trigger function. The court struck down ATF's 2018 bump stock ban as exceeding the agency's statutory authority. The Biden administration, while complying with the court order in that specific case, left regulatory text that had defined bump stocks as machine guns in place in ATF guidance documents and field enforcement policy. The April 29th package formally removes those two sentences from the regulatory definition, clearing the legal text to match what the Supreme Court held. The pistol brace official clearance, a TF's 2023 pistol brace rule, requiring registration of millions of pistol brace-equipped firearms as short-barreled rifles under the NFA, had been struck down by multiple federal courts and was already subject to nationwide injunctions. The package formally withdraws the rule, removes it from ATF's regulatory framework, and publishes official guidance that pistol braces do not convert pistols to short-barreled rifles requiring NFA registration. Owners who registered brace-equipped firearms as SBRs can request cancellation and tax stamp refunds through a process the package establishes. What this means now: federal regulatory prohibition on bump stocks has been removed. You can possess, use, and sell them subject to any applicable state law. If you registered a brace-equipped pistol as an SBR under the 2023 rule, you can apply for cancellation and refund. New brace-equipped pistol purchases require no NFA registration. Number 3. The enforcement policy transformation. What it means for licensed dealers. What the enhanced regulatory enforcement policy did. The Biden-era policy, implemented administratively rather than through formal rulemaking, created a zero-tolerance approach to FFL compliance inspections. A licensed dealer who made a single clerical error in their bound book, a wrong date, a missing digit in a serial number, a form filled out with information later corrected, faced immediate license revocation proceedings rather than a warning or remediation period. FFL revocations increased dramatically between 2022 and 2025. Critics argued it weaponized the inspection process against small dealers over paperwork imperfections having nothing to do with guns reaching criminals, serving as an effective mechanism for reducing licensed dealers through administrative attrition without requiring congressional action. What the administrative action policy replaces it with. The April 29th package terminates the enhanced regulatory enforcement policy and replaces it with the administrative action policy. The new policy explicitly reinstates tiered enforcement. Clerical errors that do not reflect willful disregard for record-keeping are addressed through education, remediation, and warning rather than immediate revocation. License revocation is reserved for willful violations, patterns of non-compliance after remediation, and cases involving trafficking, straw purchases, or conduct actually connecting FFL record failures to weapons reaching prohibited persons. What this means for dealers and gun owners. For licensed dealers, particularly small independent dealers, this removes the existential threat hanging over every compliance inspection. For gun owners, fewer legitimate dealers losing licenses over paperwork issues maintains consumer access to legal firearms commerce. Dealers will no longer face chilling pressure to avoid certain sales out of fear that any negative outcome triggers revocation. Number 4. Interstate travel and administrative cleanup. The Interstate Travel Clarification. The Firearm Owners Protection Act of 1986 provides a federal safe harbor for interstate transportation. If a person is entitled to possess a firearm in both origin and destination states, they can transport it through any intermediate state in a locked container, unloaded and inaccessible. The problem has always been transport. Courts interpreted FOPA protection as applying only to direct, continuous travel, stopping overnight at a hotel, stopping for a meal, stopping at a gas station in a restrictive state. All had been litigated as potentially removing FOPA protection and exposing travelers to arrest under intermediate state laws. The April 29th package publishes formal ATF guidance clarifying that reasonable stops necessary to the journey, including overnight stops, fuel stops, restaurant stops, and vehicle maintenance stops, do not forfeit FOPA protection. ATF will not initiate federal action against travelers who have made such stops in compliance with FOPA's core requirements. Straw purchase clarification. The package includes regulatory text clarifying what constitutes a straw purchase. One person purchasing a firearm is the nominal buyer for transfer to a prohibited person versus a legitimate gift, estate acquisition, or a purchase for another person legally entitled to possess. The prior ambiguity created compliance uncertainty for FFLs and legitimate buyers. The new guidance defines the intent element more precisely, protecting legitimate gift and transfer transactions. Administrative form changes. Non-binary gender marker options added to ATF Form 4473 under the previous administration have been removed, restoring male/female designation. The requirement for FFLs to post Youth Handgun Safety Act warning signs mandated under 1994 legislation has been eliminated as unnecessary given public awareness and existing federal prohibitions. Bottom line on ATF's April 29, 2026 Deregulation Package, Executive Order 14206 authorized, ATF Director Sakata and Acting AG Blanche implemented, 34 rule changes, 4 major categories, private sales, Biden's 2024 rule rescinded, engaged in the business definition narrowed to statutory baseline, private sales, gun show sales, and collection liquidations no longer require FFL involvement or background checks at the federal level. State universal background check laws remain. Bump stocks and pistol braces, Garland versus Cargill implemented in regulatory text. Bump stocks no longer classified as machine guns federally. Pistol brace rule withdrawn. Brace-equipped pistols are pistols. NFA registration cancellation and tax stamp refund process established. Enforcement policy. Enhanced regulatory enforcement policy terminated. Administrative action policy reinstated tiered approach. Paperwork errors get education and remediation, not revocation. Revocation reserved for willful violations and trafficking. Interstate travel. FOPA clarification confirms. Reasonable journey stops. Do not forfeit safe harbor protection. Straw purchase definition clarified to protect legitimate gifts and transfers. Form and posting changes effective immediately. Your action items. If you registered a brace-equipped pistol as an SBR, apply for cancellation and refund. If you are a dealer who received warning letters or revocation proceedings under the enhanced policy for clerical errors, consult an attorney about reopening those proceedings. If you travel across state lines with firearms, understand the clarified FOPA standard and document your journey. Know which states have their own universal background check laws before conducting private sales. Subscribe because the 34-item package is already generating legal challenges from states that oppose the private sales rule rescission and the enforcement policy change, and every development in that litigation directly affects whether these changes remain in effect.